This is LXBN TV, and I'm Colin O'Keefe. The U.S. Court of Appeals for the Federal Circuit recently issued an important decision in the patent battle between Apple and Samsung. To explain the latest, we bring in Megan Rahman, partner with Troutman Sanders and author on their blog, Virginia IP Law. First off, Megan, can you give us an update on what happened recently before the U.S. Court of Appeals and what that means going forward?
Sure. Well, the district court had denied Apple's motion for a preliminary injunction, which would have banned sales of certain of Samsung's smartphones and tablets in the United States. So that order got appealed to the Federal Circuit. And the Federal Circuit had upheld the district court's denial of the preliminary injunction with respect to the smartphones, but they sent back the order of the district court with respect to the tablet. And what they found was that they upheld the district court's order on irreparable harm, but found that Apple had shown a likelihood of success on the merits with respect to the design patent on the smartphone, on the tablet, and sent it back to the court for a finding on a balance of the hardships and public interest. So Apple has now filed a new motion for a preliminary injunction asking for a ban of sales on the Galaxy tablet. I think it's the 10.1. Samsung late Friday night filed its response. Apple will file a reply, and they're going to have oral argument on that on June 7th.
Wow, very interesting. And I know that part of this, or coming out of this, were, hold on that thought for a second. But, with so many tablets and smartphones coming out with similar features and similar designs, so many of them look like Apple iPhones and Apple iPads nowadays, with so many things looking similar, how did the court, rule the way that they did, ruling that Samsung, may have violated a design patent?
Yeah, and it is a lot about the visual similarities between the tablet, but it goes, also ruled on the irreparable harm. And some of the differences between the tablet market and the smartphone market is that the court had found in the tablet market, Samsung and Apple were really the only manufacturers at the time. And Apple was able to show that when Samsung's tablet came out, Apple's market share decreased. At the same time, Samsung's market share increased. And the court also found that they think that design matters more to consumers in the tablet market than it does to consumers in the smartphone market. So, you kind of had that irreparable harm finding that the court in the smartphone area, the court just found that there was no irreparable harm to Apple based on Samsung's smartphones. And then you do still have dual similarities between the tablets, which you do find in the smartphones as well. But that irreparable harm piece is pretty important.
Yeah, definitely. That was interesting. That's a good point on the, the market share that each company had before and after the release of this tablet, and a good piece of evidence for them to point to. And then finally, I saw, that talks between Samsung and Apple recently failed. Settlement talks that had come about after this ruling here. If this does go to trial, which it's looking right now like it's going to, what do you see as being the likely outcome for this case, for this battle between Samsung and Apple?
Right, trial is scheduled for July 30th right now. And while there are always uncertainties, and I always, hate to kind of guess what a court or a jury would do, things are actually looking very favorable for Apple. And that kind of, is, provides some guidance on the meaning of certain terms in the patent, that claim construction order. And Apple got some very favorable rulings there, which is going to be very helpful for them going forward. While it's not a foregone conclusion, it does look like they might get a nice ruling on this preliminary injunction. That's going to be helpful. And, they filed summary judgment motions on May 17th, so that will be telling as to how those come forward. And, during the actual original motion for a preliminary injunction, the judge actually held up the Samsung tablet and the, Apple tablet and said to Samsung's counsel, these look very much alike to me. Can you tell me which one is which? And the Samsung's counsel had to say, I can't, Your Honor, from this distance. So, taking all that into consideration, I kind of think Apple is kind of sitting in the driver's seat. And, really what this case is really important for is patents are usually kind of considered the softballs. It's the utility patents that are the heavy hitters. But it's really telling that, Apple takes its design patents very seriously. Aesthetics are just as important to Apple as, the mechanics of their products. And so, they're not going to stand still for copycats. You can compete, but they don't want you to look just like them.
Yeah, exactly. I mean, it's going to be very interesting to watch going forward. Like you said, Apple is huge on design. It's not just an outside thing to them. It's incorporated into the entire build of the product. So it'll be interesting to see how this plays out, and then to how other competitors react accordingly, to see how they alter the designs of their products going forward. So it's going to be interesting to watch. Once again, that was Megan Rahman of Troutman Sanders and their blog, Virginia IP Law. For more on this story, be sure to visit their publication. It's at virginiaiplaw.com. And of course, we have more on this at lxpn.lexblog.com as well. Thanks, Megan.
Thank you.